is your argument that this is yet not sorted, that unless a procedure is put in place or some sort of...
So we
don't know how to really get
three things actually, all four of them. So let's say a court can be, now Samiullah says it's a court of civil jurisdiction.
Right.
To my mind, it could be a court of criminal jurisdiction as well.
Right.
As I gave an example, cheating, for example, under Penal Code Section 415 is an offence. Section 417 says that punishment is up to 1 year. Now, up to 1 year doesn't get covered under 63(1)H. But if a person is
criminal breach of
trust, उसकी punishment ज़्यादा हो जाती है, वो शायद 63(1)H में गिर जाएगा. But anything which is less than 2 years obviously doesn't get covered under 63(1)H, but can very well fall under 62(1)F for that. For sake of what court could it be? It could be any court.
So what are you submitting? You're saying that whatever Samiullah has come up with, that is also not correct.
That's not correct.
And unless some procedure is laid down by perhaps the legislature as to what kind of declaratory orders could, or declaration could come out which would meet the requirement of 62, till then there is no declaration.
My Lord, yes. My Lord, a question was raised about 62 and 63 and their interface. And in Sabir Shah's case, 95 Supreme Court, 97, the Supreme Court says that 62 applies at pre-election stage and 63 applies at both pre and post-election stage.
Citation there, Sabir Shah?
Sir, Sabir Shah is 95 Supreme Court, page 66. And the relevant page is...
Can you repeat the citation?
PLD 1995, Supreme Court 66. And the relevant page is 274. Sideline YY. In this paragraph number 12, just, I need not read it, but it just goes on to say that the qualifications as well as disqualifications specified in Article 62 pertain to pre-election period. What it does say is that 62 contains both qualifications and disqualifications. Right. Because, and 63 obviously is entirely disqualifications, and 62, which originally was a qualification clause, and because of the violence done to the Constitution through revival of Constitution Order of 1985, D, E, F, G were inserted. Now, because of that insertion, it became a sort of a hodgepodge of both. It became qualifications and disqualifications both, and clause 2 of 62 reflects as much.
In fact, this was my question. And in any other judgment, this has been overruled or...
No, sir, this is a 12-member bench judgment, and this is by 7-5 majority, so it's a 12-member bench judgment, never overruled.